Hey guys, so today the court is supposed to rule on Marilyn Manson's request for limited discovery and request to continue the anti-SLAPP hearings. And the court has already issued a tentative order for this matter. And it's a pretty good victory for the accusers, or I should say the defendants in this case, which is Wood and Gore, as Manson gets almost nothing that he asked for. So if you recall, what he asked for limited discovery was third-party agent Michelle Langer. Didn't think that was going to happen. That's the FBI agent in Florida. Defendant Ashley Gore, defendant Evan Rachel Wood, third-party Michelle Meyer, and third-party Catherine McGaffigan, that Manson wanted to take depositions of all these people on limited scope matters. In the end, in this order, all the court is going to allow is a deposition of Ilma Gore on her state of mind when she was talking about the groupie video. At least that's how I read this order. That's it. So there'll be no other discovery before the court decides on the anti-SLAPP motions. So that's a pretty big victory for Wood and Gore in this case. They managed to hold off what Manson was trying to do, which was get more evidence to support his claims prior to the court deciding whether to strike those or not. So let's look at some of the features of the order and how the judge got to where she got to. So the court notes early on the legal standards involved, which is that discovery is stayed when an anti-SLAPP motion is filed, and also that stay shouldn't be lifted easily because discovery is one of the most expensive parts of litigation, one of the most burdensome parts of litigation. And if you just routinely lifted that stay, then what's the point of the anti-SLAPP stuff happening before some other motion to dismiss later in the case? And that's a pretty good argument. I thought it was a pretty good argument to begin with that the defendants had in terms of Manson's attorneys wanting to fly around the country taking depositions of an FBI agent, somebody I think who lives in New York. That's a fairly substantial burden to put somebody to, and you would really need to make a good case for it. But the court finds here that that case was not made. In fact, the court doesn't even find that they should be able to get a deposition of Evan Rachel Wood on any issues. So that's interesting, and much less the other people like Michelle Meyer out of the case. And as far as Ilma Gore goes, again, just related to her state of mind when talking about the groupie video. So how did that happen? So on the topic of the FBI letter, the court notes that there's not uncontroverted evidence that what Wood did was illegal because she denies having forged the letter in the first place. So, and then the court says, I'm not going to let you use discovery just to test the contentions of your opposition. You'll need to go with what you've got or what's in the complaint. And then in terms of the recruitment situation, the court notes the various statements the parties have tried to enter to support or rebut that, and does something which is really great, which is says, I'm not going to pay attention to these double hearsay DMs from Ashley Smithline. So the court says, I'm not going to pay any attention to that, and it sustains the objection to that, which is cool. Then, in terms of the other two statements that Manson had, the court says, well, even in those messages, it's stated that there's no pressure to participate. You're not obligated to speak in any way. And the court finds those things, that doesn't look like an outrageous conduct, those activities themselves, that these messages to these people, that's not outside the bounds of a civilized society. That's not extreme and outrageous. So the court's not going to order any discovery on these issues. And reading between the lines, it doesn't look good on the anti-SLAPP side either in terms of the claim surviving based on these allegations, because the court doesn't find those to be very bad at all. Also more interesting to me, a pure legal perspective, is the defamation claim. Because it noted that, Wood was not accused of having said any of this stuff, but rather to be only involved as part of the conspiracy against Manson, that then she would be liable for what Ilma Gore may have said if there was liability for that. And the court says, just based on what you're telling me that you've gotten a complaint, I don't see that this meets the level of conspiracy. The court does not find the allegation plaintiff points to in his reply concern facts of Wood's knowledge that the defamatory statements about Groupie were being made by Gore, and that Wood intended to aid in achieving the objective of making such defamatory statements. So the court is saying that other than conclusory things, you haven't stated something that shows that Wood knew that she was saying this stuff about Groupie and that it was part of this conspiracy that you say that they have. So again, that looks pretty good if I'm Wood, that this thing is going to get dismissed as to her when the ruling comes down on the anti-SLAPP. On Manson's side, the court was not persuaded that the mere allegations by the defendant, Gore, that Manson had said virtually identical things about himself in terms of the groupie video was enough to let her off the hook, and the court was not convinced by that at this point, and therefore is going to allow discovery on this issue. So the court is going to allow discovery, i.e. a deposition of Ilma Gore on the issue of her intent and actual malice when she was making these statements about the groupie video. And that's it, though. The other things that he wanted to question Gore on, the court did not allow those, and no deposition of Wood at all. So finally, at the bottom of the order, the court says that I've granted this in part and denied it in part, and that Gore's motion to strike will be continued to blank. That date is not filled in. It does not say that Wood's motion to strike is going to be continued. So this leads me to think that the court has done not only an analysis on the discovery, but also an analysis of the merits of the anti-SLAPP motions themselves, and is prepared to rule on at least Wood's motion to strike. So that's going to be extremely interesting. Reading this order, which is really only related to discovery, but if you read it in terms of how the judge is leaning, it looks very good to me that the judge is going to throw out the case against Wood for the defamation claim, and maybe as well for the intentional infliction of emotional distress claim. And then that would leave Wood in the case only on a potential conspiracy hook for the computer-based claims. So it's a good day for Wood to read this order. Of course, they're going to sit around waiting, I'm sure, for the next order, which is actually the ruling on her anti-SLAPP motion. But this certainly leans in her direction, and it gives the defendants almost everything they wanted in terms of opposition to discovery. That may be a mindset into how the judge feels about these anti-SLAPP motions, and that maybe they do have merit. Not necessarily. The judge can also think, well, I'm not going to throw these claims out, but I'm also going to have bifurcated discovery. I'm going to go ahead and rule on it. Then the parties can do real discovery when they get into it. That could be the case too. But reading the overall tone of the order, it definitely looks like the court is going to parse this complaint according to the intent of the anti-SLAPP law, look at it carefully, and it's not going to give any free runs to Manson's side. And so it looks to me like things have tilted over in favor of the defendants at this point in this case. A good day for them. So that's it. Thanks.